Real Conversations with Johnnie Finch. Let's cut to the chase. It's May 2020. All of us know about the Ahmaud Arbery situation, the catastrophe that happened down in Georgia. So I called my friend, Attorney Harry Daniels, preeminent civil rights Georgia attorney, to come and speak to you about these situations, how he goes about analyzing them. He's going to help you, number one, if you're looking to be a civil rights attorney. Number two, if you just need, a motivational thought process, he was going to share with us his analysis on these situations and on these cases. And number three, I've been asked quite a bit what a non-lawyer can do in this situation. What are the steps that they can take to try to assure that when the justice process starts, that there's not a 74-day pause before someone who murdered someone in cold blood is arrested. And so he gives a great take on what you can do. I appreciate you guys. Please like and subscribe. Let Attorney Harry Daniels know that you appreciate him and ask him to come back. Real Conversation with Johnnie Finch. Let's go. Civil rights attorney, Mr. Harry Daniels. Thank you for being here today, brother.
What's happening, brother? I don't know about the comfort, but I'll take it though.
Yeah. Well, I tell my NC audience there's only once in a lifetime that certain breeds come along. And I'm not embellishing when I say you get your LeBron Jameses, you get your Kobe Bryants of the world, you get your Tiger Woods of the world. In the legal field, we get those as well. And I meet a lot of lawyers on a daily basis. But there's a special group that seems like they've been bred since day one. And when they come out, when you hear about them, you always hear about them. One, because of their work ethic. One, because they're always giving to the community. And two, because they have their ears to the community. And Attorney Harry Daniels is definitely one. I'm proud to say he's a good friend of mine, a brother of mine, and also always fighting for the injustices that we have. Now, he is a true civil rights attorney, and I know that term is thrown around quite a bit. We want to really talk about what that actually is, man. So when we talk about civil rights and a civil rights attorney and a true specialist like yourself, what exactly are we talking about, Attorney Daniels?
Well, what we're talking about is someone who's, like you said, that's definitely concerned with the public and some of the injustices that's going on with the community. It happens a lot in the community. I say it happens, injustices, not just some of the things you see at a larger national stage like the Ahmaud Arbery shooting and things that capacity like Trayvon Martin, but small things such as somebody's being discriminated against on the basis of age, religion, or disability, race, so many different things. Now, it may not be glaring, but as a specialist, as somebody who really does civil rights, really know how to get to the bottom of to see if these injustices are actually taking place or somebody's civil rights are actually being violated. And when you say civil rights, you talk about the rights of the Constitution. But a lot of times the rights are not such as glaring that people say, hey, my civil rights is violated. Hey, I was arrested, or the police didn't do this, or what have you. There's certain things that I look at, my team look at, my law firm, that we really stay in tune with the breathing law. The law changes daily, especially in this arena. Cases go to the Supreme Court of the United States all the time. Cases dealing with a plethora of things dealing with people's rights, from human rights to gay marriages and so many different things. And not just at the Supreme Court level, but at the local district court level, as well as the Court of Appeals level. So as a civil rights attorney, I really stay abreast. I read a lot about the law. I study different cases, because in any job, any job that you have, not even a lawyer, you always want to stay vested and in tune with your skill. Just like a doctor having a new surgical procedure or anything, you want to know the latest procedure, what to do, so you don't be archaic and be in the times past you. But the civil rights attorney is one of those things that you really have to be bonded to, John. I mean, you got to be really vested, because a civil rights attorney, by virtue, you're going to become an appellate attorney as well. Just know that,
Mm-hmm.
It's a lot of gray areas, and a lot of it's subjective of how the courts and how people of different, a different opinion, they may see things differently. So I love my job. I love being a civil rights attorney. It was something I didn't grow up or in law school said I want to be a civil rights attorney. I was fortunate to meet and spend some time with one of the most known civil rights attorneys in our area, in our time. That's Attorney John Burris out in California. His wife actually taught me in law school. She taught me property and family law, something that I don't do either. But I mentioned her about civil rights, and she hooked me up with him. And I actually fell out of touch. When I got out of law school and started practicing, I started doing contracts. I like contracts. Worked for the federal government, went up to George Washington to pursue an LLM in federal procurement law. Then I'm like, hey, man, this ain't for me. This kind of, I like doing it, but I don't think this is what I want to make a career out of. I left D.C. and I came back to Georgia. I actually came back to my hometown, Carrollton, Georgia. It was about 35 miles west of Atlanta. And I took a job as a public defender. I took a job making substantially less than what I was making with the government. I think I started off like $40,000. I was almost making almost $90,000 or almost $100,000 to government. So came back home and got into the court system and saw some of the injustices that was taking place inside the criminal justice system, being a criminal defense attorney. You talking about disparity of sentences, same crime, different color, different outcome.
Talk about it.
And, I saw some of those things happening and, it didn't sit well with me. And a lot of times when I was a public defender or a defense attorney, I would make a fuss about it. Like, hey, look here, you got this one person who engages in a burglary. You have this next person who engages in a burglary. You give this person probation. You give this other person 5 years in prison. The only difference is the color of the skin. There's no difference in criminal history, education, anything. So I would make a point, and as one incident where the judge realized that, that I don't think he per se realized that what he was doing, what he was doing and not doing, I brought it to his attention, like, hey, this is the problem. And he, in fact, reversed his sentence, some African-American males who were sentenced to prison, and gave him probation because it didn't sit well. One, it is going to be a major issue across the circuit, at least for me, major issue for me, how you can give one person probation and the other person a prison time. So
wait. Slow down on that note just a little bit. You brought this to his attention in the courthouse?
I did.
Doing an open forum?
Yes. Well, I knew that a case was being one case was being sentenced in one courtroom, the other case was being sentenced in the other courtroom. So what I would do, I would like, let me see what's going on here. Now, I've done this several times, John. This is nothing new for me when I was a defense lawyer. I would sit and listen. I would look at the docket and see who have similar charges. I would listen to the as a prosecutor, do a resuscitation of the facts, recite the facts, and I would see, oh wow, this is a home invasion robbery, and this person did probation. Okay, we got a home invasion robbery, and I would bring it to the court's attention, like, hey, as your honor know that a case just was sentenced 2 dockets ago, and when this person got probation, and my client when he went home the gun, so I expect to get the same deal. And I think as that type of demeanor and that type of fight for the public at large is the things that kind of set me aside, and I was afraid to speak up. Was afraid to bring this to the attention because a lot of people say, well, he had a different lawyer. No, ain't no different lawyer. Justice should be blind. What's good for the gander is good for the goose.
Exactly.
All right.
Exactly.
And I would point it to the court's attention. And sometimes I would do things and say things, and it's not as take kindly to some of the powers that be, some of my supervisors, but nevertheless, that's who I am, and I believe in justice for one, just for all. So.
Yeah, and that's quite an interesting thing, and a theme. I know in North Carolina we have a public. I guess every state has a public defender system. When you were working that job and you were making these arguments, what 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 were your supervisors saying at that time? Were they telling you, ho, hang up? You know, we're fighting hard, but we're not going to fight too hard. What was their overall attitude? They were like, hey man, this is what we've been waiting for. Fight.
Listen, I had some great folks I worked for, but you know, a lot of time people who've been in a system for so long don't want to ruffle feathers, man. You know, I haven't been I wasn't in the system that long, you know, and you know, I got into the system to fight the injustices. So when I would see them, I would make a fuss at them. One thing about me that a lot of people don't know, especially where I'm from, is that in Carroll County, had a brand new courthouse, beautiful courthouse, has a Confederate memorial statue, soldier in front of the courthouse. The statue would also have the rebel flag, people would call, which is actually the flag of the Northern Army of Robert E. Lee of Northern Virginia. And that's the rebel flag that people refer to with the old Dixie cross on it. Well, that flag would be put out on that statue. And you know, I got tired of it. Got sick and tired of it. One day I took the flag, removed it from the statue, took the flag with me, took it into the courtroom. As soon as I walk in the courtroom, the judge, kind of like you just did on your in your chair, sit back, look. You know, didn't say anything, but I was ready for the fight. Ready for him to say something. He's a good guy, good judge. You know, he was like shocked when he saw that flag. And you know, my thing's like, yeah, the same way you shocked as I brought this flag in the courtroom, the same way a lot of people be shocked when they come to court seeking justice, that this flag of oppression, this flag of tyranny, this flag of hate is flying at this courthouse. So I removed the flag, took it down. I got one of the law enforcement officers, didn't take too kindly of it, and I told him to arrest me. I said, you got a problem with it, arrest me. You know, I'll be that martyr. I'll be that martyr for justice and change. Arrest me. Don't make no difference, because this flag would not fly when my grandmother paid her taxes, when your grandmother paid her taxes. It will not fly on public ground. I have opposition with the statue as well, but that's a whole different talk.
Sure.
But took it down, and that the city actually passed an ordinance, made it a misdemeanor for anybody to put a flag up like that again. So took the stance, you know, to be bold, to do it, and the flag have yet to ever fly at that courthouse again, that Confederate flag.
Do you think your dad was a professional boxer, wasn't he?
Yeah, man, he was.
Do you think you take that same fighting spirit that he had as a boxer into the courtroom? Is that where the fighting spirit comes, you think? Or, you know, is it innate, or how do you?
Well, I'm by nature. Well, I'm by nature very competitive. I remember, you know, growing up, you know, playing kickball or whatever, and I got to win. But you know, if you're gonna do something, you try to do it at the fullest to your potential, greatest potential. You know, that you have, that God has bestowed upon you, your gifts and talents, and you try to do it at a high level within your realm of your potential. And when you do something, I don't believe you do it. You don't do it halfway. You do it all the way. And I take that spirit with me as a civil rights attorney in a lot of different arenas. You get tired at times. You know, you can, I'm sure you can attest to that as being a lawyer yourself. You know, you get tired, but you know, when you get tired and you physically start getting tired, and you feel like you're beat down, you think about that person who has entrusted you, all right, who entrusted you, who may be working a 9-to-5 job, you know, a minimum wage job, who's been discriminated against, who has, you know, barely getting by making ends meet. You think about them, and when you think about them, it's a spirit that comes upon you, and you know, that gives you that extra up to keep fighting. So that's the fighting spirit. Yeah, my dad a prize fighter, but there's a very fighting spirit that I have, and I'm always going to fight for my clients and fight for the people.
I see. Going back to the specialty and being a civil rights attorney, I for one know that that's not an area that many people at all delve into at all. They don't want to touch it. And so when you say that you're always reading and you're always trying to sharpen your craft, how do you do that when you don't have that many individuals who are elite in that area, or the law is always changing? Are you actually the thought leader in the civil rights realm, and are you just reading this and are you actually perfecting it as you learn it? Because there's not so much information on it if we're actually looking at it, other than what everybody already knows.
Many have tried and many have came short. And a lot of times, you know, Johnny, when I tell you, you have a doctor, for a normal head cold or ache or whatever. But when you need a surgeon and you have a specific issue, you have to go to the surgeon to remedy it. I'm not saying that I'm above anybody else by any stretch of imagination, but you have to know how to bring these cases. It's a lot of pitfalls. You got to think about it. As a civil rights lawyer, you are usually making claims against a governmental entity.
Yeah.
All right. Majority of the time, or a person who has cloaked with power that been bestowed upon them by a governmental entity.
Like a police officer.
Police officer. So you already starting at a disadvantage. Okay. You have the state, county, or the city, or any governmental entity that you're going against. Or it could be an individual you're going against, but that individual work for that governmental entity. That's how you get to those particular claims of violation of my civil rights. All right, in a lot of cases. So you start at a disadvantage from the beginning, that you have the weight of the opposition on you. You have to know how to, one, bring the claim. You got to know who to sue and how to sue them. You got to know what to say in the complaint, how to allege it in the complaint, because high scrutiny are on these cases. You can have a absolutely shut down case factually, but if you don't know how to allege it, to bring it the right way, or sue the correct party, you'll lose. Now, you'll be grateful if you get a motion to dismiss filed without prejudice and the statute is not run, you can bring it back. But if you get a summary judgment, that's a adjudication on its merits, and that's a final order.
So when you say that these cases are highly scrutinized because you're bringing it against a governmental entity, are you speaking to the politics behind it, or the law?
Everything about it. I would tell you, as a civil rights attorney, we are very in tune of who our district court judges are. So when a president appoint a district court judge, we are very in tune of who that district court judge is, their history, where their stance on civil rights. Have they ever even had a civil rights case? Have they ever practiced in that area? Because a lot of times, the judge has no experience, and a lot of times a district court judge that's newly appointed to the bench will take with them a law clerk who's been with them in state or superior court, who never dealt with a 1983 case or a Title VII case. So you need to look and really know what a judge's position, judge's stance. If you got a judge that come from, as they quote unquote, big law, and a lot of times they did employment law, employment discrimination, then you're probably gonna have some problems with that court. But I tell people, prepare your case. One of my mentors told me a long time ago, prepare your case for appeal, even though we're at the trial level.
Yes, sir. You know, Harry, you went from being a public defender, and you said you got with one of your longtime mentors. And at that particular point in time, is that when you started your own firm?
I started my own firm after a murder case. I tried a murder case in Georgia, and it had a lot to do with the stand your ground provisions in the laws. That's in Georgia. Some of the things that's going on with the Ahmaud Arbery case now. But in that position, my client, our argument was that the stand your ground is unconstitutional in a sense because it's not being equally applied to black defendants and white defendants. My client was charged with murder and convicted after a long held out jury. From a jury went from swayed from not guilty to swayed to guilty to eventually a Allen charge. If you know anything about criminal law, dynamite charge, and they eventually found him guilty of felony murder. I don't think the jury really understood the law in that capacity. But the facts in that case, my client was in a nightclub. An individual was looking to shoot and kill a person. He saw that person. He pulled his gun out to shoot and kill, and my client shot him. The jury could not reconcile that a person could, in fact, take another person's life and, in fact, be innocent because they're justified under the law of defense of himself and defense of others. It was like him being in Twilight Zone. That case is still going on appeal. Some other things going on with it. I don't really want to get too far at that.
Sure.
But after that, I like, you know what, I got to go out and fight these injustices at the root, because I believe that if you fight it at the root and get the right people in there and certain officers, that he probably would never been charged. At all.
So what I'm hearing is that while you were doing the criminal defense work, you felt a certain pain for your client that couldn't be remedied as a criminal defense attorney, and therefore you wanted to be able to affect change from a larger stance, and so that made you go out and start your own firm. Now,
yeah, from a larger. I'm sorry.
No, I was listening. From
a larger, affect more people. I mean, obviously, criminal offense, you one person at a time. But when you get a law change or establish some case law, then that affect the masses, affect a entirety, at least a region of people in a particular circuit.
Sure, a good example of that. And if you mind delving into it just a little bit, I was reading an article today where one of your clients was shot with a taser in the jailhouse. In that case, were you able to affect change from a larger position as a civil rights attorney? And if you don't mind, if you can talk a little bit about that.
Yeah, my client was an inmate at a local facility here. He was placed inside a restraint chair, and anybody who worked in criminal defense or worked inside the jails know that the restraint chair is there to put on a person who deemed to be is not conforming or to the procedures of the jail or whatever. And that can be subjective a lot of times, put a person in a restraint chair. Anyway, he was placed in a restraint chair. And at some point while he was in the restraint chair, one of the detention officers tased him, drive-stunned him, when he took the actual taser cartridge out and burned my client's skin multiple times. It's actually captured on video. I guess they didn't realize that the camera was rolling. The officer was, in fact, he was arrested and charged by the GBI. He was went before the grand jury, but a no bill came back because in Georgia, the officer had been charged with a crime, get to go before the grand jury and try to make their peace in case and talk about how old they are and what things going on in life that may have them to do this. Unlike other defendants, they get an opportunity to go and speak their piece to the grand jury. So nevertheless, we brought a claim in the northern district of Georgia.
Let me stop you 1 minute, Attorney Daniels. Let me stop you 1 minute. Okay, guys. So for everybody that's always talking about all these legal terms on Facebook that they know nothing about, if someone's arrested on a felony in North Carolina, it has to go through grand jury. And what that grand jury looks like is generally the law enforcement officer will go in the back and he'll give information about the case. And if the grand jury finds a true bill, then it'll be bound over to what will be Superior Court in North Carolina. What Attorney Daniels has described to you is this: the actual defendant in the case, the actual person who was charged, was able to go in front of the grand jury and plead to his case why it should not be a true bill.
Right.
How does that happen? How does that happen, Attorney Daniels? Is the DA did they allow that, or because it was his case? Like, how does the officer, how is he able to go and plead his case before the grand jury?
Well, the law allows them to do that. Now, the law may have changed at this point, but the law allows a law enforcement officer to go in, and they get to do, and the grand jury don't even get to ask questions to that person. They get to do basically a narrative to the grand jury. The DA does not even get able to ask questions to that person. Now, they might have changed that now, but I know at the time, DA didn't get an opportunity to ask questions to the person. They just get going in front of the grand jury and say, hey, I'm Harry Daniels. I messed up that day. Whatever the case may be, and basically play on the hearts of the grand jury. The grand jury sent back a no bill. Not really based on the law and the facts, because the law is very clear that he committed a battery, an aggravated assault on this person.
I see.
It's on video.
Yeah, I see, and I'm assuming that he didn't show the video to the grand jury.
No.
Yes, sir. So, moving past that, you said so there was no grand jury bill passed. What happened next?
We took it case to the federal courts, a violation of a civil rights, and in fact, let me go back here. You have a state law where a person can be charged violation of the office. That is a person who has taken an oath to uphold the law, usually law enforcement officers. I don't know if North Carolina have the same law. And he was charged with a battery, misdemeanor battery. Should have been aggravated assault, misdemeanor battery. The United States Attorney's Office, Department of Justice, also can bring charges, criminal charges, in violation of a person's civil rights. That's operating under the color of state or law. They can bring federal charges against a person. A person who's operating under the color of law, who uses that authority to violate somebody's civil rights. And those are federal charges, criminal charges. What I do is I bring civil charges, civil actions. So we're talking about getting injunctive relief, declaratory judgments, and money. Mm-hmm. All right. We brought a claim against the officer directly in an action to say that he violated our client's Fourth Amendment right, right to unlawful seizure of his body, which was being tasered multiple times by this officer, among other claims as well. We present the video at the summary judgment stage. Summary judgments is when at the end of discovery, the judge get all the facts, put all the facts in the record to determine if it's enough disputed facts. I say A, you say B, and those facts has to be material. And it can't be, it just cannot be, I say A, you say B, A and B had to be genuine, real facts that a jury can pick either A or B. Well, in our case, and if you don't have those disputed facts, I mean, any lawyers listening, you're going to lose at a summary judgment. Well, in this case, we had a video. And I was like, we have a video. There's really no need the video speaks for itself. That is the best evidence of the case. So essentially, we put the video on the record, and we did something that a lot of plaintiff lawyers do not do. We filed for motion for summary judgment against the defense. A lot of times, plaintiffs are reactive. Go ahead, I'm sorry.
No, I was saying okay.
So a lot of times, plaintiffs lawyers are reactive to defense filing a motion summary judgment and responding. Well, we filed a motion summary judgment. They also filed a motion summary judgment. That's usually standard in what they do. The court, in a 100-page order, denied their motion and granted our motion summary judgment on the basis that the defendant violated our client's Fourth Amendment right. He committed battery, and he denied his right to qualified immunity. Real quick, qualified immunity is when an officer who engages in an act, and for some odd reason, commit that act, and not knowing that this was a violation, or subjectively not knowing it's a violation, you should look at it objectively. They are granted qualified immunity. I put you, I arrest you. You should have been arrested, but I didn't do it intentionally. So we're going to get an officer qualified immunity. And that's what I was telling you. When you start these cases, you already got so much law and so much precedent that's already going against you that you got to overcome so many hurdles to get your day in court in these type of cases. So anyway, we sent over a motion for summary judgment. The judge granted 100-page order. The defendants were shocked that they lost, because at that point the judge only want to hear one thing: how much money does my client get awarded from a jury? That's a scary position for a defendant to be in. How much money? You violated his rights. You committed a battery. I don't need a grand jury to determine that. The judge determined it based on the law and based on objective evidence that probably was not presented to the grand jury in the first place. Grand jury proceedings are secret, so you don't know what's presented to the grand jury. Just like in the Mike Brown case, hands up, don't shoot. You don't know what the grand jury was told, but you do know that the officer got a chance to go inside the grand jury with his lawyers to talk to the grand jury. So judge saw it, granted the summary judgment in our favor. Of course, the defendants, what they do? They appealed it to the 11th Circuit. Appealed it to the 11th Circuit. The 3-panel judges in the 11th Circuit affirmed our summary judgment. What the defendants do? They request for a full bench hearing from the 11th Circuit. 11th Circuit looked at it and unanimously shut it down, said they would not hear it. So basically, this case went all the way up to the 11th Circuit for a full consideration for the full bench. Full bench said no. At that point, there was no request for stay to grant certiorari to the Supreme Court of the United States. So at that time, the case was mandated back down to the district court, and that case basically became the law of the 11th Circuit. When I say law of the 11th Circuit, Alabama, Georgia, Florida, the 11th Circuit of the United States, and also persuasive authority for any other circuit or lawyer in the United States who want to use that case as persuasive argument in that case. So that's what I'm talking about when you have a case and you can affect so many. So now, if it's objective evidence, and if objective evidence is the best evidence to use, the courts review the objective evidence, and when it pertains directly to restrain inmates who cannot fight back or cannot resist, and they are subjected to excessive force, then I advise all plaintiffs' lawyers, if you got the video, file a summary judgment, because you got the law behind you from the 11th Circuit of the United States to say summary judgment should be granted.
Yeah, and that's definitely a big win. But took a little bit of creativity on your behalf, though. What it sounds good now, you know, that you're telling us that, but what made you feel like if it had done before in that particular situation, it was going to work in this particular situation?
Well, I don't know if it's ever been done before, but I do know that a lot of times it's not done. And every time I talk to other counsels, defense counsels in these cases or plaintiffs' lawyers, they say they've never done it before. And some of these lawyers have been practicing law, never seen it done before. They've been practicing law for 30, 40 years. And they never moved for summary judgment in these type of cases because, you know, thinking that it's so fact intense. Because usually in a summary judgment, if a defendant is denied summary judgment, they have an automatic right to appeal. And that case go up to the circuit, and the courts may say, well, they're entitled to qualified immunity, even though you won the first wave and you end up losing. Or you go through trial, and they get the appeal after trial. Now, when it comes to a liability and it was a violation, did a violation occur, it's over. But in my mind was thinking about there's no genuine material fact. A blind man can see that this man was restrained. All right? A blind man can see that he suffered significant injury. So if justice is blind, how about I give it over to blind justice and see what she see? And she saw the same thing.
Awesome.
Clear.
Now you are in the state of Georgia, and as a civil rights attorney, are you allowed to go to different states and represent individuals when they've been injured?
We do civil rights cases all over the United States. I currently have a civil rights case pending actually in your district, in the Eastern District of North Carolina. Very crazy case up there, dealing with some officers alleged to putting a gun to a deputy sheriff, his fellow officer's head, and using the N-word multiple times.
Mm.
And in fact, the people who complained about it was fired, and we got that also captured on video. So
you
read
are,
between the lines.
yeah. So you are able to not only affect change in your district, but you are allowed to go to different states as well. Man, everybody's been talking about it, man. It's something that has been so recurring. At least once or twice a year, we'll get one of these cases. As a civil rights attorney, what do you see in the Ahmaud Arbery case?
It's a lot of things that I see in the Ahmaud Arbery case. First, I'll see a tragedy. First and foremost, it's a tragedy that I see, that a young man was gunned down in a manner in which he was, or any young man gunned down for any manner is a tragedy. But so many different narratives have come out of it. You're talking about him jogging, going inside a construction house under construction. The people who killed him trying to utilize the Georgia citizen escape law, detainment law, to justify their legal platform to be able to stop him. But as a civil rights attorney, this is a case where the individuals involved, and I'm talking about the individuals who pulled the trigger, who were responsible for pulling the trigger, what they saw is a black person, or whatever they wanted to call, doing whatever, and they took an opportunity to exercise their ideology and try to justify their actions. So regardless of if they were justified in responding or whatever, they saw the opportunity and they took that opportunity. And I think it had a lot to do, well, his race. Because when you look at this whole thing in the totality, look at what was said, what was done, and as we know the facts now, that he obviously wasn't afforded the same deference or the same explanation that somebody else would have been afforded, but for, I believe, the color of skin. Because they easily could have asked him, hey man, what were you doing in that house over there? Hey, I was just looking. I didn't take anything. Okay, well, all right, man, you need to be careful about going in things like that. No. They immediately assumed, because of colors of skin, that he had to do, he broke the law, he did something. And they took their guns, their weapons, and they hunted him down, blocked him off, and killed him.
Yeah.
Bottom line.
Attorney Daniels, what leads you to the conclusion that the purpose that they did that was because of the color of his skin?
Because they talked about other blacks who have been breaking it in their community, burglarized their community, and that was a lie. There has not been any other burglars.
All right. Is that community close to you in Georgia?
No. That's close by Savannah. So when you say, "Oh, we chased him because there been reports of a black male breaking into homes," that wasn't true, then that tells you they try to put it on another identifier, somebody else being a person of color, to try to justify their actions of why they went after. But that ain't true. They went after him because he was a black. Mm-hmm. That's what they went after him, and try to come up with a story to justify their actions. That's why I believe it's race component is a part of it.
Yes, sir. Now there was the actual act. Tell me what you think about the process and how you analyze the process, and if you see any possible claims from how the case was handled after the untimely passing of Mr. Arbery and how the state handled it.
Yeah, well, the local district attorney obviously intervened early on, to my understanding, and reported that the local law enforcement wanted to had probable cause to make an arrest the day of the incident. And the DA, I think her name is Jackie Johnson, intervened and told them not to make an arrest.
The elected DA.
The elected DA. She intervened and told them not to make an arrest. Then subsequently, another district attorney was assigned the case in which he recused himself. But at the point of recusal, he sent a letter to the captain of the police department saying that he found no probable cause whatsoever. Now,
but slow down, Attorney Daines. Slow down, Attorney Daines. So initially, Ms. Johnson, the elected DA, said that there was decided not to do an arrest, and then was that another elected DA that came along that wrote this letter?
Right, another DA was assigned. She recused herself because I believe that one of the father, my understanding, used to work as an investigator in that particular office, district attorney's office, but she told the police not to make an arrest that night when they want to make an arrest. Now, you know well as I know that the police does not operate, don't work to the will of the district attorney. The prosecuting officers, they bring the charges, and they bring the file, they bring the charge to the DA. The DA make a decision as to prosecute the case, but the DA does not make decisions to make an arrest. That is not their grounds. They are not ones who make decisions to make an arrest. The arrest could be, in fact, wrong, once you go through the case and deem to be unjustifiable or the person be vindicated, but it does not stop a law enforcement officer who believe they have probable cause to make an arrest to, in fact, arrest that person. So she intervened at the early stage. She intervened in the early stages of this matter, which I believe thwarted the investigation in its totality and made the case go cold. When you make a case go cold, obviously you got less opportunity to get a conviction. So we went 70 plus days with a cold case, all right? With a cold case of arrest, or somebody been arrested and such, and kind of thwarted the investigation of the murder, which in turn could have a long-term effect and a very critical in the determination as to whether these people, one, get indicted and or get prosecuted and found convicted. I think the DA is actually currently under investigation from the state at this juncture. As a prosecutor is under investigation. I think the state bar need to get involved in this matter, and some type of civil action really need to be viewed upon as to whether the Ahmaud Arbery's family rights were violated by preventing the investigation or chilling the investigation. Mm-hmm. A lot of people don't know this, or a lot of people think that just because you're a prosecutor that you have absolute immunity. You may have absolute immunity on how you try a case. Mm-hmm. How you try a case. But you do not have absolute immunity if you get involved in an investigation and you are an actor in investigation and through some type of fraud, cover-up, or misrepresentation, you can be held liable, which brings a family back to a person like me, mm-hmm. a civil rights lawyer. Yes, you look at those particular claims to pursue justice to ensure a proper prosecution, and not just that, but recourse and anybody who played a hand in the chilling or the false misrepresentation that thwarted the prosecution. In fact, you're talking about, it's so many different things that possibly took place from not wanting to make an arrest. Stories could have got on the same line. Willis, when law enforcement make an arrest, they interrogate the suspects in different rooms, evidence, they go get warrants. They go get warrants to search your house while they got you in confinement or when they interrogate you. Well, these individuals got a chance to go back home. Had to go back home to tamper and possibly destroy evidence.
Attorney
There's
Daniels,
so many.
and Attorney Daniels, that town that you're talking about, is this a big town or a small town?
John, I don't know. I don't know. I've never been there.
Okay.
It don't sound like it's too big though.
Yeah, sure. And the things that I hear, and everybody knows, we've all seen First 48, and the whole premise of the show is, if something doesn't happen in 48 hours, then they say the case spoils. And so at this particular point in time, they definitely had someone known to be the shooter. They definitely had someone who had passed at that point. These individuals, for whatever reason, were not arrested for 74 days. And it appeared to me that there was a lot that went on between then with people requesting the action happen. In your even smaller towns, a lot of times, and people always say, in your smaller towns, that's where all of the action happens. What if national attention didn't come to this case? What if the right people weren't, what if it wasn't brought to their attention? They may still be out in the street today. Tell me what you think about that. Like, we're in 2020. We're in 2020. What can the average citizen do? Obviously, when you come onto the scene, you're going to prosecute the case. You're going to make sure that the rights are afforded, or however much money is awarded to the person. But as the average citizen, because I get so many emails myself about, what can we do about this as a layman? What can citizens do to try to make sure? Obviously, we can't make sure that people aren't being shot. That that's individuals making that decision. But on a larger scale, what can the average citizen do?
What a regular citizen can do is, one, if you feel that your rights have been violated, make a complaint. Make a complaint to that entity. A lot of times that certain agencies have a complaint procedure form that you can make a citizen complaint. And you may say, well, what that's going to do? What that does is make a record of it, right? You can send a certified mail, return receipt, know, one, that you sent it certified mail with tracking, return receipt that they received it, okay? So they can't get any dispute later, they didn't receive it. Make that complaint to, I don't know, lieutenant, major, captain, chief, whoever, sergeant. Make that complaint, make a record of it. Hey, this is what I'm complaining of, right? If you don't get any redress from there, go to your city council, the county commissioners, the mayor, county manager, whoever, your Congress, state rep, senator. Let it be known and keep pushing the envelope that, hey, you are making people aware of what's happening. I've seen a lot of times where constituents make complaints to their congressman, senator, and they make a phone call. It's one thing we get a call from a United States senator, like, hey, I got a call from my constituent, Johnnie Finch, and he's complaining about XYZ. Can somebody look into this and see what's going on? Well, a lot of people get concerned when you get the Senate calling, because they have the ability to do inquiries and investigations and by the United States Senate, depending on what committee they sit on. So it's very, very important that you let it be known. Go to the media. Go to the media. If you got a video or something's going on, get your voice out there. A lot of people try to, like, I'm gonna do it in secret. It's actually better if you do it out in the open, in the public, because, one, you can be protected. If something transpires, you're concerned about some type of retaliation, usually a person are not going to retaliate against you once everybody knows you got some issues with them. Because if something happened to you, that's the first place that investigators going to look at. Well, they did make a complaint about XYZ, and they were saying they said it was going to that XYZ did something, so that may gave that person motive to do something to them. So be open. Don't be secretive about it. local community leaders, stand up in church. Go to church, a person of faith, stand up in church. Let people know what's happening. Scream it to the ceiling, to the heavens. Let it be known. Somebody will hear it. It will get across somewhere, and somebody who will hear it, who can do something about it. Somebody like myself who has the capability to get things on a larger media and larger scale to bring things to public attention, public awareness, and start a process. But do not, I tell you, do not hold it to you and say, well, this is the way things are and this is how I've always been. You are a procurer of change, and you have to make that step to make change.
Man, that's some really good information. I know a lot of people have been continuously asking me about that, so I'm glad you could share it. Let's just back up just a little bit. Tell our audience a little bit about your legal training. Where'd you go to Harvard, or did you go to UCLA, or where did you go to law school?
I went to North Carolina Central University in Durham, North Carolina. I'm a legal eagle.
Tell me about that process. And let me say before you get into that, here in North Carolina, and I have a lot of love for Regent University. I went there. The people on the ground floor who are making things happen, grassroots, 9 times out of 10 went to North Carolina Central University. And I have no reason to tell you any other difference. The movers and the shakers, the people who are helping the community, who are progressing the community, the judges, a lot of times are straight from North Carolina Central. I have nothing but the utmost respect for that university. Tell me about North Carolina Central, and tell me why somebody might want to consider to go there.
Well, North Carolina Central is a great institution. A lot of times they, have a thing where somebody who otherwise would not be able or accepted to it in certain law schools, so they'll take a chance on you. Now, I'm not saying you can just get in there with any old LSAT score. You got to have a pretty decent score, but definitely take a chance on someone. We give you opportunities to let you to apply and try to be a part of this legal profession. And if you get in there and work hard and you really, really try and study and learn, and you have no problem passing the bar. And like you said, man, North Carolina Central alumni are doing amazing things in the state of North Carolina, and not just the state of North Carolina, but all over the United States. It's a phenomenal school. The professors really care. They really want you to not just to get through it, but really learn your craft. I graduated 10 years ago, and I'm not that old school seasoned lawyer by a long shot, but they put a challenge before you, and you have to rise to the occasion to meet that challenge. And if you meet that challenge, I'm sure you'll come out on the other side shiny as gold.
Sure. Now, along with that, you mentioned that you came out of law school 10 years ago, and while you look like you're 30 years old, I don't think you're quite 30. You might be on the other end of 30. Not quite sure. What did you do before you went to law school?
Oh man, I was actually in the Air Force.
Okay.
I served in the Air Force for 8 years. Believe it or not, my job in the Air Force had nothing to do with law. It was fire protection. I was a firefighter for 8 years. I was a professional firefighter in the Air Force. Drove the red truck, ambulance, you name it, exactly the firefighters you see in the city. Go and fight fires, delivering babies, climbing trees, get cats. That's what we did. Also, we dealt with jets. Has been an Air Force firefighter, and I am a war veteran. My squadron led the attack in the Iraqi war. I was there when it happened. So I was there in Iraq, in the Middle East, at the beginning of the Iraqi war. When you talk about shock and awe, I was right there on the ground. I spent time overseas, combat veteran. Once I got out of the military, I worked in law enforcement for a brief stint. I actually worked in Mecklenburg County Sheriff Office down in Charlotte. A lot of people don't know that about me. Worked in Mecklenburg County. From there, went to law school, and I've been doing this ever since. So I got a little background coming into law school. I wasn't too green, but I've seen some things.
A lot.
Served in the military.
Sure.
Inside the
How did
jails.
those two professions merge? Was there anything that you took from your life experience beforehand that you say definitely, whether it was working with law enforcement or being in the Air Force, that you were able to take into your career, or was it just life experience or anything glaring that helps you today?
Well, obviously, those two professions, well, three professions really, if you were to break it down: military, uh, law enforcement, and firefighter. Those are very blue collar jobs, very blue collar, hands on, hardworking individuals that work in those and who work in those jobs. So I took that blue collar approach, and I still take that blue collar
Yeah.
approach.
Mm-hmm.
John, I would tell you, man, my wife can tell you that it could be 1 or 2 o'clock in the morning, and I'm reading cases. I like being a lawyer. I like learning the law on the TV. I shut the TV off and do some studying, do some reading, to better myself and not just better myself, but to better the people around me and be a better advocate for the community. When you come to me, you have 40+ thousand attorneys here in the state of Georgia, and even more across the United States. You got a choice who you want to pick as a lawyer. So
Mm-hmm.
you want to make sure you go somebody who's competent, willing, able, and ready to take on the challenge, to represent you. And I pride myself in doing that. I'm not always successful. I'm not going to sit here and lie and tell you that I win all the time. That's not true. But I do fight hard all the time for you. And it's something that I don't know. It's not above me. I'm not too prideful to ask, hey, I need help, or bring somebody else in who may have more experience. Because at the end of the day, it's incumbent upon me to be a zealous advocate and bring in the right people and attack the right angles to be a success in this profession and help so many people who need help in this day and age.
That's awesome. You mentioned your wife. Tell us a little bit about your family life. So you're a married man, yeah, two daughters.
Married man, got 2 daughters. I got one. She just graduated from Wake Forest.
Awesome.
She graduated. She's kind of bummed out. She should get a walk in commencement due to COVID-19. But they go. Actually, I think the commencement celebration is going to be on Halloween. So I will be in Wake Forest on Halloween celebrating her. She's a joy. Love every ounce of that girl. I got a 14-year-old who is something else. She's told me that she's gonna take over my practice, and
Oh,
she's gonna put me out.
yeah.
So I told her I'm waiting for you.
Oh
So
man. You
so
know,
she
that's
go
incredible.
ahead.
That's incredible that she desires to walk in your footsteps. Says a lot about how you carry yourself as an individual, because obviously if you were moping around the house all the time, she probably wouldn't want to do that profession. Now,
Well, I don't say I don't mope sometimes, but I know she she came to work with me this past summer, and I'm thinking summertime. She puts her little skirt on, or her like she's ready to go to court herself.
mhm.
And she actually in her class, they had a little mock trial competition, and she raised her hand first. She wanted to be the criminal defense lawyer, and I had a actual real trial myself. That was I was in the middle of a real trial. So if you're in trial, I got home real late,
Mhm.
and she had to do an argument the next day, and she waited for me on the couch. As soon as I walked in, she jumped up, said, "Dad, I'm ready to help me on my opening statement." So imagine being in a real trial, having to do your own, and you had to, you got to help a 14-year-old in middle school to get ready. We got ready. We stayed up for another 2 hours. She wrote it out. She practiced it. I recorded it. Man, she came ready to rock and roll. And and her teachers told her like, "Hey, you definitely have found your niche." So and she saw Daddy will go the extra mile to push them, to a higher level, even a great higher than me.
Of course, of course, of course.
Oh yeah, and
I,
I can't forget about my beautiful wife.
oh yes, please talk about her.
Uh,
We all know she holds it together. we all know the importance of a good support system at home. I think when what I talk about a lot is, as lawyers in high pressure situations, we don't have the capacity to have a lot of missing notches. And so whenever I'm speaking with people, who you marry is a choice. Who you marry is an absolute choice. And once you get into the law profession, if your mate, man or woman, is not holding up their end in whatever way, whether it be mentally unstable or whatever is going on, it weighs on your practice. And so you have all those issues. You can't deal with life issues, your client's issues, whatever else is going on. You know, it gets tough at times. Tell me how you maintain a work-life balance with everything that you have going on.
Yeah. Well, my wife is great. You know, I was still in school. You know, if I'm working in my office in downtown Atlanta, you know, we're doing things. You know, she's always, you know, making sure the kids, Christian is good. You know, the family is taken care of, and you know, she understands that that you know my job is, you know, is very, very important. As much as just as well as I understand her job is very important as well. You know, and she's you know she's very supportive in so many different capacities. If it's simple things of getting dinner or whatever, ask me, you know, if I need anything. I know can she help with anything? Because she knows that it's a definitely a delicate work balance. And as you know, being in this profession, that you do. Some people say don't take your work home with you, but it's inevitable as a lawyer that you have to take that work home with you. And she give me my space and time, and you know when it's work time, grind time, I'm on it. But I'm just as you know, I'm out to have fun and whatever. You know, just let me knock this down. Let me get this finished. Hey, I'm 100% committed. Always gonna be committed. You know, if it came down to it, my family or my profession, I'll always pick my family. I can always find another profession.
Yes, sir. Yes, sir. Yes, sir. Attorney Daniels, I definitely appreciate you coming here for this quarantine series, man. I know probably the only time I can get you in there, man, because you're moving and shaking so much, man. Again, you know you're my brother. I love you to death, man. I'm going to post all of these links to the different cases that you talked about, as well as your social media presence. But just let everybody know how they can get in contact with you on social media and your office information.
Well, I don't know too much about social media. I got a Facebook. I believe the firm have a social media, Twitter and Facebook. Daniels and James. My law partner is Robert James, a former DA down here in the city of Atlanta, DeKalb County, and portions of Atlanta. We are at Daniels and James. We are located in Atlanta, Georgia. Our phone number is 678-664-8529. DanielsandJamesLaw.com. Or it's DanielsandJames.com. I'm not sure. I don't really look at my website. But we do, like I said, we do civil rights. We do personal injury, medical malpractice. We are a true civil litigation law firm. So if you're in the Atlanta area or anywhere, you know, anywhere in the United States, if you feel like injustice have taken place and you need a lawyer, call us. We go anywhere. We'll come anywhere. Wherever injustice may lie, we'll do our best to help you out. And if I cannot be the lawyer and I cannot get to you, I assure you I will help you find the right lawyer.
Which is big. And just real conversations, Johnnie Finch. I'm out of here, but I'm gonna let Attorney Daniels just, if you don't mind, just speak a little motivation into our audience today. I want you guys to comment below. Maybe we can get Attorney Daniels to come back as we have these civil rights issues coming up, because they pop up 2 or 3 times a year. So maybe we can get them to come in on maybe on a 15, 20-minute segment. If we don't do the whole hour and a half. But just if you don't mind, Attorney Daniels, just take us out of here. Real conversations. Johnnie Finch, do your thing, sir.
Listen, guys, thanks, Mr. Finch, my partner, for bringing me on. He's being very humble. John is a great lawyer. He works hard for the public, for his people, and he's a real pillar of his community. He's blessed. The community's blessed to have him. I know he's blessed to have his community where he practices at. Listen, guys, be encouraged. I know we got a lot going on through this pandemic, but this too shall pass. We are a strong nation, a strong people. I know we got things that's happening that's trying to divide us more than to bring us together. Just know as a people, as a unit, that we are made equal through our Creator, whoever you believe that Creator may be, and you are more than enough able and capable of being whatever you want to be and helping anybody you choose to help. I'm out.
Thank you, Attorney Daniels. Real conversations.
All right, man.